Good morning, everyone. Welcome to the Kansas Court of Appeals. My name is Henry Green, and I will be the presiding judge this morning. Here with me, the other judges are Stephen Hill and Judge Gardner. Now, the name of this case is the Kansas Government Ethics Commission, the appellee versus Fabian, Shepard, and Cheryl Reynolds. They are the appellants. This case has been set for 15 minutes, and I need to get the appearances for the parties. Appearing for the appellee,
Caitlin Bull Stewart.
And appearing for the appellants.
Yeah, Judge, my name is Chet Compton, and I've got a law clerk that's also in my office with me, Elizabeth Rapor. She's going to be just observing today.
Okay, Elizabeth. Mr. Compton, would you want some rebuttal time from your...
Yes, Your Honor. 3 minutes, please.
3 minutes? Let me... Are you ready to proceed with your argument?
Yes, I am.
Okay, we're ready to hear it.
Okay. May it please the court, this appeal asks a single question, and I want to get right to it. The question is, can the Governmental Ethics Commission, which I'll refer to as the government here, can it satisfy its burden of establishing a likelihood that it will get the court to order the enforcement of its subpoena as written? That question, of course, comes from the second prong of the Public Speech Protection Act. That is the act upon which this motion has been made. And that act has a two-prong analysis. It's actually statutory, and our courts have fleshed it out through case law. But the statute provides for a two-prong analysis. The district court ruled in the defendant's favor on the first prong, so that issue is not before the court. On the second prong, in our opinion, of course, the district court erred in denying the motion, and this court reviews the district court's determination on that second prong de novo.
How did they get it wrong, counsel? Let's get right to it. What did the district court find that was incorrect?
Well, I will get right to it. What the district court found, basically on the second prong, it defined the parameters. It defined that initial question correctly. We believe, in our opinion, it defined it correctly, that the burden is on the government, and that's clear from the statute, and that the government must prove a likelihood of prevailing on its claim. And it defined the claim appropriately, in our opinion, that the claim was that the government had to prove a likelihood that the court would enforce its application for order compelling production of documents in which it requests the court to issue an order compelling the defendants to produce records. So
well, you've just repeated your claim, but now tell me, how did it get it wrong? Where is it incorrect? That's what I'm trying to figure out.
Okay, so the court ruled that it would not enforce the subpoena as commanded, and then it denied the motion. Why did it do that? Because it found that the subpoena had two categories of requests, and it found the first one was the one that was extraordinarily overbroad. And it is clear from the face of the subpoena that it is extraordinarily overbroad. But then it found that some parts of the second one that it may be likely to enforce based on the information available to it at this time. And so based on that, this is where it erred, Judge, based on just finding a portion of the subpoena that may be enforceable, it said the government satisfied its burden And we believe that that is incorrect because.
Are you asking us to reweigh it then?
I'm sorry?
Are you asking us to reweigh what the court did, or just substitute our judgment for what the district court ruled?
Yes, Your Honor, this is a de novo review. It's based completely on the statute. This is completely a matter of law. This is an interlocutory appeal taken, yeah, sorry, go ahead.
Oh, I'm following along your reasoning here because I'm trying to,
okay.
I'm trying to find the error that is reversible. And basically, I think what you're telling me is the court said this portion is appropriate and you should honor the subpoena. And you're saying it isn't, but I haven't heard any explanation why it isn't.
Well, no, our explanation is not that the subpoena is completely without, if you look at it in a vacuum, that every single request made in the subpoena is not enforceable. We believe that's not.
The district court trimmed part of it already for you, but left this, right? Because it granted you relief on part of it, didn't it?
No, Your Honor, and that's where we believe it erred. It completely denied the motions, even though it ruled that it would never enforce the subpoena. It said that upon a different objection that hadn't been made yet, it would never enforce the subpoena. That's where we believe the district court erred. At the very least, the district court should have granted the motion in part on the provisions that it found to be extremely overbroad and that it would never enforce, because that's the second prong. And the government can't meet its burden to show a likelihood of prevailing on its claim to enforce those issues. Of course, it's not, it is the master of it authored the subpoena, it authored its application to enforce its subpoena, and it seeks to enforce every single one of those things. We believe that the PSPA requires it has a burden on the government to establish a likelihood of prevailing on what it's asking the court to do, and that is the court to grant everything.
So your argument is that the court has to grant all or none because that is the claim.
That's correct. That is the claim, exactly. And to rule otherwise, basically what the provisions and the subpoena, which the district court correctly found to be overbroad, the government essentially on appeal is saying, well, we proved that some things could be maybe have a likelihood of being enforceable, so the court ought to just modify. But just to be clear, the district court didn't modify. The district court at this stage just completely denied the motion.
Well, can we order it to? Can we reverse it and send it back and say, trim those portions off that you find objectionable?
Yes.
Can we do that?
Yes.
Is that the relief you're asking for?
No, Judge. We're asking to strike the whole thing, because if the government, when it becomes, we're talking about, of course, we're not talking about the first prong here, which is talking about First Amendment, but clearly the First Amendment applies here. And the purpose of the PSPA, which is to encourage and safeguard the constitutional rights of the people to petition and speak freely and associate freely, to allow the government to essentially say, well, as long as we can put in one thing that we can prove to a court that we're likely to prevail on, as long as we can just include one thing, then that will serve as a shield to everything else. And it will not become subject to the PSPA. And I think that's exactly backwards from the purpose of the PSPA. It's exactly backwards from applying and construing the PSPA liberally to effectuate its general purposes, which is what the statute instructs the court to do.
Is there anything in the act that says it has to be all or nothing? The court can limit the subpoena to certain items and strike other requests?
There's nothing in the act specific to subpoenas. We believe that the act is clear on what the government's burden is here, and that is to show a likelihood of prevailing on its claim. And again, its claim is for everything. It's the one that gets to decide what its claim is.
But doesn't the court always have the power to modify a subpoena, to quash a subpoena? Why can't it do the same thing here with this one? It's a little bit premature because we're not at that stage yet, but we're looking at the likelihood of that. So why would the courts, having done what it did here, saying this, in the event it reaches the stage of objecting, this would be objectionable, I wouldn't enforce it, I would enforce the rest. Why isn't that okay?
Because we're talking about the First Amendment and the PSPA. And these are highly protected things that the legislature has said are extremely important and has expressed its goal of protecting.
But do you have any authority to cite to us that says that in this context?
Well, there is authority out there that on motions to strike based on the act, they partially grant. There are cases, and we've cited them. I think it's the Churchinelli or something like that case that we cite in our brief, where there's partially granted motions to strike, but there's nothing specific to subpoenas. No, there is not. It's not a very well developed area of the law. Mm-hmm. But we believe, I mean, the government in this case talks at great length about what a low bar it has on substantial competent evidence and what a low bar that is. And they're largely correct. I mean, it is a low threshold.
Because it's reasonable suspicion, correct?
Right. The substantial competent evidence. Yeah, I think it's like reasonable suspicion. I think that's right. Well, if you draft a subpoena that includes requests that you can't even meet what you claim is the low bar of proving a likelihood of enforcing, and then you file an action to enforce those requests that you can't even clear that low bar, you are putting your whole subpoena in jeopardy, because you may not be able to show a likelihood that you'll prevail on your claims. Otherwise, you can just name one thing that you think is enforceable and then try the best you can and just throw everything else in there. This is exactly what I think the answer to your question, Judge Gardner. This is exactly what the PSPA was intended to do. And the remedy is to strike. It's not to modify, it's to strike if the defendant can't satisfy its burden. We're talking about First Amendment territory. This is highly protected territory. And here the government can't even clear its low bar of substantial competent evidence that its subpoena, as it requests, sorry, I misplaced it. I'm reading from the application, it wants the court to issue an order compelling the defendants to produce records as commanded. The question is not whether part of this is acceptable or not. The question is whether or not it can prove a likelihood under this low standard of compelling the defendants to produce records as commanded. That's what it's asking the court to do. It's the one that authored these requests, and it's the one that authored the prayer in the application. So it's made its bed, and now it should be forced to lie in it.
So you have mentioned the First Amendment a couple times, but we don't have a transcript about the hearing on the motion to strike. When we look at what was the motions and the response, we really don't see any First Amendment things being raised at that point. So I'm wondering, can you give us some insight into, was this raised during the hearing on the motion to strike?
Yes. The First Amendment privilege is what you're talking about.
Well, your constitutional claim.
Yes.
First Amendment protections.
Yes. It was raised. I mean, I don't have the exact, I think our brief goes into exactly where we raised it. I think it's actually our reply brief that goes into where we talked about it, but clearly the First Amendment has been part of our motion here. And so, I don't have the exact citations for you offhand, but I do think that I would direct you to our reply, which I think that we address that.
So you're claiming that by filing your motions to strike under the KIPSPA that you necessarily are invoking your First Amendment privilege as a defense?
Absolutely.
That's your position?
Yes. And I think the case law is very clear that the court has to, that we have the right in determining the likelihood of whether or not this subpoena is going to be enforceable to raise our affirmative defenses. And so that's exactly what we do. We raise our affirmative defenses, and they've got to come forward with substantial competent evidence to refute those affirmative defenses. And again, I think the case law is very clear that affirmative defenses are in play on this motion.
But what do you say to the government's argument that that's procedurally premature?
I say that it would be really ironic to find that under the PSPA, which is designed to be filed before an answer. That's its design, is to be filed before an answer. And it's also designed with the goal of protecting First Amendment rights. That how ironic would it be that you can't raise or you can't consider an affirmative defense based on the First Amendment because you filed a PSPA motion? I mean, there's no reason why the court shouldn't consider affirmative defenses in determining whether or not the government can meet its burden of showing a likelihood of prevailing on its claim.
What's your injury here under the First Amendment?
Well, my clients are volunteers that have done nothing wrong. They've not claimed to have done anything wrong. And they have been dragged into court, and they have had articles written about them. This is very public. They haven't done anything, even though they've got all these news stories out there that are talking about how they've got an ethics claim against them. In this ethics case, in this punitive action by the Ethics Commission is really what it is. It's harassment. It chills free speech. It's exactly what the PSPA is designed to protect against. How hard do you think it's going to get people to volunteer for their local Republican parties if they've got to face a subpoena that asks them to turn over all communications, texts, emails, everything from basically everyone connected by a political thread, everyone associated with the party that they work with? I mean, what does that even mean? It's potentially limitless. So, I mean, the harm, I think, is clear by the harassment that they faced and being dragged into court and having to defend themselves against this. So I think we've talked.
Mr. Compton, I'll go over to keep. Yeah, I'm still going to allow you to keep your rebuttal time, but you need to kind of bring it to close to be able to keep your rebuttal time. You know, another couple of minutes, can you make your point, and so you can keep the rebuttal time?
Sure, Your Honor. I think just for a couple minutes, I'll talk about point number 2, because I think we've talked about, there's really 3 arguments. The first is the government exceeded its authority by issuing an overbroad subpoena. There's that limitation requirement that we brief, and they clearly have violated that limitation requirement to keeping its subpoena limited to information about its investigation. The second thing I would just say, the second argument is our affirmative defense, and we've talked a little bit about raising that. I want to talk about relevance. Again, that goes to the overbreadth. B, the second part of the First Amendment privilege is necessity. The government claims to have the smoking gun against this other guy that they're investigating. They have the smoking gun already. Why are we intruding into the First Amendment rights of the defendants? It's not necessary. C, other sources. How about the guy they're investigating? How about, I mean, that would be the most obvious answer. If they need to continue to investigate, they already have the smoking gun. Now, how about the committees? Instead, they go after these low-level individual volunteers. And then the last one that I'll say, and then I'll let the other side go, is the nature of the information sought. And again, I kind of covered this. This is what I think in our briefing we call the sweet spot for First Amendment: freedom of association, freedom to petition. These organizations are designed to petition the government and to protect speech. So, and then if I have time in rebuttal, I'll go ahead and talk about the third issue, which is there's the underlying issue with the KCFA claim that there's an underlying violation. Unless there's any other questions, I'll just wait for my rebuttal.
Thank you. Ms. Bull Stewart, you're up next.
Mr. Presiding Judge, and may it please the court. Good morning, Your Honors. I'm Caitlin Bull Stewart, appearing on behalf of the Kansas Governmental Ethics Commission, ex-rel Mark Skoglund, Executive Director. I will just call it the Commission henceforth, the plaintiff appellee in this matter. And I urge this court to affirm the district court's holding and denying the motions to strike and the request for attorney's fees for two clear reasons. The first is that the Commission provided substantial competent evidence of a prima facie case that its subpoenas would be enforced by a court, either with or without modification. And second, the defendants have failed to provide adequate defenses sufficient to defeat the Commission's prima facie showing. First and foremost, as has been alluded to, this is a discovery dispute, and the district court treated it as such. What is the claim at issue here, as aptly framed, is a subpoena, and what prevailing on the claim means when a subpoena is the claim. Significantly, the procedural vehicle that the defendants have chosen, the PSPA, the Public Speech Protection Act, does not allow for partial striking of claims or modification of discovery tools such as subpoenas.
Wait a minute, just a second. Just because it's in the act, does not the court have the right? A subpoena is a court order. Doesn't the court have an inherent right to limit its orders?
Respectfully, Your Honor, that is an excellent point in that, yes, the court does have a policy discretion typically to modify subpoenas, but that is usually presented to the court through the procedural vehicle of a motion to quash a subpoena, not through the Public Speech Protection Act, which textually does not give the court the authority to modify the subpoena. It only allows for a striking of a claim. It does not allow a partial striking of a claim or a modification of a claim, which is why it is not the appropriate vehicle to handle discovery disputes.
Well, I'm trying to see what the district court did wrong here.
The district,
explain that to me.
The district court did nothing wrong, Your Honor. The district court was correct in finding that the Commission prevailed on its claim because, again, when the claim is a subpoena, all that requires is a showing of some level of enforcement. It is irrelevant if portions of the subpoena are unenforceable, so long as the ask whenever a subpoena is filed requesting for enforcement is just that some of it be enforced and some of the information sought be produced.
So you're telling me this isn't a little mini trial that you have to prevail upon for your commission in order to issue a subpoena. Is that correct?
Can you rephrase the question, Your Honor? I'm not sure.
It sounds like to me that your opponent is arguing, look, the state has to show that they're going to prevail on every point or they don't get to issue a subpoena. Is that correct? Am I misstating the argument?
No, that's correct. That's the argument coming from defense.
What's wrong with that? What's wrong with that argument?
That argument's problematic because it essentially imposes an impossible standard on the Commission. It would require our subpoenas to be utterly perfect when they are issued by the Commission. So I provided the example in my briefing that if a subpoena has some defects, such as it asks for privileged information subject to attorney-client privilege or First Amendment privilege that the Commission could not inherently foresee, that would render the subpoena utterly enforceable with their interpretation of our statute. And is also unworkable with how district courts usually handle subpoenas. They're granted the discretion to modify to handle discovery disputes. As the Supreme Court has recognized in Cessna Aircraft, courts generally, they have three options when it comes to subpoenas. They can enforce as written, they can modify, or they can completely deny. In a world of defendant's interpretation, they do not allow the district court that discretion. As has been mentioned, only prong 2 of the Public Speech Protection Act is at issue, and that simply requires the commission to provide substantial competent evidence it would prevail in its enforcement claim. Here, to compel enforcement, the commission must just show substantial competent evidence that there was a reasonable, that it complied with the requirements of 254158D, the 2022 version, which is the commission's subpoena issuance authority. That requires the commission to show it had a reasonable suspicion of a campaign finance violation, and that it provided copies of findings and conclusions to the subpoenaed parties if they requested, and that the vote requirements were met. Very little of this has been disputed. The findings have not been disputed. The only real argument raised by defendants relating to the conclusions of law are that they allege that the prohibition on giving in the name of another, which is the violation of KSA 254154 subsection A, they contend that the commission's reading is novel, and so it is not a legitimate conclusion of law. However, they are not appropriately explaining how this is a novel reading. There has been no argument that the statute is ambiguous or how the commission is acting differently than it has in the past when interpreting this statute. For example, the commission has many advisory opinions, such as that cited within the brief, advisory opinion 9745, and also the Kansas Supreme Court in a case in 1991, State versus Palmer, addressed a criminal case that dealt with violations of giving in the name of another. Essentially,
may I ask you, when we look at Attorney General opinions, we have given some weight to them, and there are cases that have analyzed them and say, here's how we handle those. Do we have any Kansas cases that say, hey, here's how we look at an opinion, advisory opinion from the KGEC? From the commission?
No, there is not. So it would just be under the persuasive authority that the court affords to administrative decisions. However, the reasoning of the citation to that opinion is to show that the commission has consistently applied the statute in the same way when asked by members of the public, and in case law as well. As I mentioned in that Palmer opinion, it dealt with an illegal pass-through scheme that was a reimbursement in which a business executive wanted to exceed contribution limits, so had his employees make contributions to candidates and then reimburse them. This was not completely analogous to the matter at bar, but it is an example of where contributions are being passed through different entities and shows that the commission has consistently followed this same approach as the one at bar. Additionally, the only authority cited whatsoever, which comes out in the reply brief on appeal for the argument as to why 254154 and that prohibition on giving in the name of another is problematic, is the FEC versus Swallow opinion. However, that opinion is just about the FEC exceeding its authority awarded under the statute regarding enforcing the federal prohibition on giving in the name of another. And the FEC added language to its regulations, the help or assist language, that were not present in the federal statute. That's all the FEC versus Swallow opinion is. It's not dispositive. And importantly, the issue of the vagueness or lack thereof of 254154 is not properly presented to the district court nor to this court. This is not, they do not actually make the ask of rendering the statute one way or another. Further, regarding the interpretation of the commission's issuing authority, which is 254158D, as Judge Hill asked about earlier, the statute is being misread in a way that would require utter perfection upon the issuance of a subpoena. This is an entirely unpreserved argument and is not made whatsoever at the district court. Defendant's interpretation writes the words upon issuance into the statute. To put it another way, defendants would read the statute in a way that renders a subpoena entirely unenforceable with even the most minor defect. This is inconsistent with the general policy of allowing district courts to modify subpoenas. Furthermore, the statute 254158 sub D explicitly contains language that allows a court the discretion to modify its subpoenas. It states that subpoenas ducis tecum shall be limited to items reasonably relevant to such alleged allegations. This gives the court the discretion to modify the subpoenas because, importantly, the commission has no authority to enforce its subpoenas by statute. It must seek judicial enforcement, which is why it is drafted this way, so the district court can determine which requests for information are binding on the subpoenaed parties. Additionally, the shall be is a future tense, which means it would allow for the district court to modify it later on.
Counsel, that may I interrupt you there? That seems to me to mean that the legislature intended for an independent body to determine what can and cannot be subpoenaed. Is that correct?
Yes, Your Honor. The district court allows the commission, while to issue using a reasonable suspicion standard, it leaves it to the district court to modify, to narrow the subpoena as is appropriate.
So why can't the court do that in this case?
It's because, again, the wrong procedural device was used in this case, because the Public Speech Protection Act is an all or nothing strike tool. It just says a claim may be struck. It does not allow a court to strike a portion of a claim, although defendants attempt to put that reading onto the statute on appeal. That is, it does not give the court that discretion. So under a motion to strike, the court either strikes the entirety of the subpoena or they enforce the entirety of the subpoena. It does not give them any authority to modify. And in fact, the defendants only offered authority on this, Karen Cheney versus Peck, does not stand for the proposition that portions of a claim may be struck. Karen Cheney dealt with a 5-count complaint, and each individual count constituted a claim under the PSPA. So different counts may have been dismissed, but they were dismissed entirely. Entire claims were dismissed. And again, this is different because it's a subpoena. It's not a petition requesting relief with various different independent claims. The subpoena is requesting enforcement of the information, whether or not upon modification.
So, counsel, let me go back, because you've come a couple times and said PSPA is all or nothing, which is really the argument that the defendants are trying to raise for the first time on appeal, but you agree with it. And so, but you haven't cross-appealed by saying that the court was wrong in saying that she wouldn't, in fact, enforce the whole subpoena, just part of it. So how are those positions consistent?
Those positions are consistent because the question is what prevailing on the claim means. And so when the district court denied the motions to strike, she appeared to follow the same logic of it's all or nothing. So in her denial of the motions to strike, she indicated that because the commission would, because the court would find the second set of information more narrowly tailored and enforceable, that the court found the commission still prevailed on its claim. Because again, in the context of a subpoena, the ask of the court is different than if you were to file a lawsuit asking for the court to find damages or to do some type of declaratory judgment. Finally, defendants have failed to mount adequate defenses against the subpoenas. Thus, the commission prevails under prong 2 of the PSPA motions. Defendants must win their absurd and unworkable interpretation of 254158D, that subpoenas must be perfect upon issuance, to prove that overbreadth actually dooms the subpoena's enforcement. Defendants never contend that the second portion of information sought is problematic. They admit, in fact, numerous times that it is narrowly tailored. And importantly, while they do attempt to raise a First Amendment privilege, this is not a First Amendment constitutional claim. They are not alleging that their rights are clearly violated. That's why they don't get access to this test. So first, it's procedurally premature because they don't lay out what is even subject to the privilege. It's hard for a court to apply a balancing test if it doesn't know what it's balancing. Additionally, if this court nevertheless applies a balancing test, the balance still tips in favor of subpoena enforcement. Because
Do we have anything in the record that we could even balance to perform this test?
no,
This
Your
is
Honor.
an interlocutory appeal, right?
No, Your Honor, that's the problem, is there was no privilege log, there was no highlighting of what was privileged. And sure, the PSPA does not require an answer before it's filed, but some communication to the court and the parties of what information may or not be privileged is necessary for a court to engage in a balancing test. There can be no balance if the court just knows the subpoena exists and it doesn't know what to balance it against. That is why the balancing test is procedurally premature and the way that this case has played out. I see that my time has expired. May I briefly conclude?
Yes, you may. I did allow the appellant to go over, so yes.
Okay, thank you, Your Honors. To briefly conclude, the balancing test weighs in favor of the enforcement of the subpoena. As has been highlighted, there's nothing to weigh against. And just because a smoking gun has been found does not mean that there is not additional information. The defendants were in charge or were part of the PAC or were in chairperson positions of the political action committees at issue and are positioned to have critical communications that would be necessary to further understand what happened to determine if a violation did occur. And I respectfully request this court, in considering the foregoing, to uphold the district court's decision denying the motions to strike and requests for attorney's fees. And when the issue under the Public Speech Protection Act, when the claim is a subpoena, a party prevails under prong 2 of the motion to strike if it can demonstrate the subpoena is enforceable, either with or without modification. Thank you, Your Honors.
Thank you. Mr. Compton.
Thank you, Judge. I want to read from 60-5320. This is the act. It says, and this is the second prong, if the moving party meets the burden, which it's talking about the first prong, that's already been decided that we have met our burden. The burden shifts to the responding party, in this case, which is the government, to establish a likelihood of prevailing on the claim by presenting substantial competent evidence to support a prima facie case. Here's the claim. The KGEC requests the court to issue an order compelling Shepard to produce records as commanded by the subpoena. So, this is not a first time argument on appeal. The question in the second prong is whether or not as commanded. Ms. Bull-Stewart says, we read into the statute a requirement that the subpoena must be enforceable as written. No, the claim must be enforceable, and the claim is to compel the defendants to produce records as commanded. So we've got the standard, and we've got the claim, and we've got the district court appropriately finding, and I believe this court will find as well, that the subpoena's demands, the district says, the subpoena's demands, quote, encompass information far beyond what is reasonably relevant to the violations alleged. It called the subpoena unacceptably overbroad. And it said if an objection is made and the government asks the court to compel a response, defendants' objections would be sustained and the court would not compel a response. Now, I find it very interesting. I read the government's briefing on this, and they seem to be all about modification, because they know that first category and some of the second category is completely indefensible. It completely it's way overbroad, and it violates the limitations requirement in the statute that gives them the authority to issue the subpoena in the first place. They know it. It's clear from the face of it. When there's a question about, what's privileged, just read the subpoena. That answers the question. But I find it very interesting today. Again, in their briefing, they talk about modification. Today, they take a very bold approach and they say that this court shouldn't modify. That's very bold in the face of a subpoena that clearly it clearly cannot enforce as commanded.
Are you saying that we lack the authority to remand this with directions to modify the subpoena?
No, Your Honor. I think, what we would ask the court to do obviously our first argument is to strike the whole thing. But if the court doesn't agree with that, the instructions, in our opinion, ought to say to grant the motion to strike on those things that the court finds that the government doesn't have a likelihood of prevailing on. At the very least, that ought to be what the court did, is a partial granting of the motion to strike and granting of attorney's fees accordingly, just like the Kirchinelli case, or I don't know if I'm pronouncing that right, but we cited in our brief with the partially granted a motion under the PSPA. So that's what I would say to your answer, Judge. I would say, yeah, if you remand, if you want to, for lack of a better term, split the baby, I don't know. The instructions would say grant the motion on those things that the government can't satisfy its burden on. That makes complete sense to me. So, and again, with respect to this, does the subpoena need to be perfect? The focus is too much on, does the subpoena need to be perfect? What happens if...
Counsel, it seems to me the thrust of your argument, and I think the commission is arguing, that if we go with you, we're saying all you have to do to stop a subpoena is to file one of these motions, because anything can be broad enough to be First Amendment speech. So you could always stop a Governmental Ethics Commission subpoena by filing one of these lawsuits. I think that's the essence of what I may be wrong, but what's your reply to that?
Well, I'd say you got to measure it against the statute. They're the ones that issued the subpoena. They need to be issuing a subpoena that complies with the First Amendment. Like they themselves say, their burden is low, substantial competent evidence. Why can't you just clear that burden? That's the reason the burden is low. Just issue a subpoena that is not, facially overbroad as they have, and then go clear your low bar. I mean, that's what the PSPA is intended to do. It's intended to communicate to the government, in this case, the government, that we take the First Amendment seriously, and we're going to protect it. There's nothing, Your Honors, preventing the government from limiting its subpoenas after issuance. Why are we even here? When we filed our motion, why not just say, oh, we're going to reissue a subpoena and we're going to take away all the information that is facially overbroad? What about doing that after the district court made its ruling that these things were unacceptably overbroad? Just remove them and reissue a subpoena. But they don't want to do that because the legislature knows the abuse that this commission has been doing, and they changed the statute to require before issuance that they go to the district court now. If that was the way it was today, we'd never be here, because the subpoena never would have even been issued in the first place. The district court said so. So, I would say, obviously, I think I've made clear that our primary argument is strike it all, because they can't meet their burden. The statute sets forth their burden clearly. They want to, come hell or high water, they want to enforce every single provision in their subpoena. And in the alternative, we would ask the court to partially grant our motions based on, at least striking those portions that the government can't meet its burden on, not just throwing out the PSPA in its entirety, because there's one good claim maybe good claim that the court finds. So I think my time has probably expired. So unless there are any other questions, that's all I have.
Are there any questions from judges today?
No. Oh, I'm fine.
Thank you. We appreciate both arguments. You really have given us something to think about. Appreciate your arguments, and we were trying to get your opinion as soon as possible. Thank you, and have a good day.
Thank you.